Good afternoon, everyone. Allison Schaberg here with Consolidated Planning Group. Thank you for taking the time to join us today. We are here with Randy Narkir with the Florida Legacy Law, and we are going to be talking about special needs trust today. So you are in the right place, and we're glad that you've joined us. I always like to share a couple of housekeeping items. We are in webinar mode today, which means that we can't see you or hear you, but we do know that you're here, and we're glad that you're here with us. We invite you to put your questions in the chat box today, and we're going to get to as many questions as we can during the time that we have together. So just to talk a little bit about Consolidated Planning Group. Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, and certified in special needs. And, we serve families like yours in planning for the future of a loved one with a disability. I myself am a parent to multiple adult children with disabilities, and a lot of our webinars were really born out of my own frustration on why is everything so hard. As a parent to kids with disabilities, everything we do is challenging, lots of questions. Honestly, there's a lot of misinformation out there, and it's hard to navigate all of that. So we've been around for over 30 years, and we help families just like yours plan for the future of a loved one with a disability. When it comes to planning, what we do in our role and what Randy's role is a little bit different. Although we get calls all the time with from people saying, I need to set up a special needs trust or I need guardianship. I shorten that up to say that he's the paper, the legal documents, we're the money. How much money do I need to fund that special needs trust that the special needs attorney set up? Who's going to care for my child when I'm gone? We help people set up ABLE accounts. We do a lot of lifetime care plans, protection plans, and we do a lot of advocacy by way of our webinars. Consolidated Planning Group has a YouTube channel. You can subscribe to that for free. There are over 500 webinars on planning for special needs. If you can think of a topic, it is probably out there. We talk about public benefits, SSI, Medicaid, when to apply, how to preserve eligibility for state and federally funded programs, and how to have money in the right buckets for said programs so we don't lose that eligibility. And so one thing that I always like to share with the families that we talk to is that when it comes to planning for a loved one with a disability, whether it's your child or a sibling or another family member, your situation is specialized, and I highly recommend, whether you work with us, or you work with Randy, or you work with somebody else, I highly recommend that you work with a specialist that is specifically nuanced with special needs, because sometimes there are a lot of financial advisors out there. In fact, there's about 260,000 financial advisors. Fewer than about 150 have any background in special needs. And what can happen accidentally is that you can have money in the wrong buckets and lose that eligibility for programs such as SSI or Medicaid and things like that. And then when it comes to your legal documents, I always say, you may have a neighbor that's a real estate attorney and they said that they'll do a special needs trust for you for free. Just say no. You really want to work with a professional that is nuanced in this, because when we have documents that are completed by people that are kind of just dabbling in special needs, sometimes those documents are just wrong. And they may not even be construed as the bona fide special needs trust in the eyes of the Social Security Administration. So it's really, really important to get the right people on your team when it comes to planning. So when it comes to planning, thinking about things of who's going to care for your child when you're gone, developing a future care plan now will answer these questions. We encourage people to really think about these things when you're of sound mind and body, not waiting for that crisis to happen. Somebody's been diagnosed with something terrible, there's been an unexpected death or things like that. When it comes to transitioning and transitioning into adulthood, we think about post-high school options. What are we going to do? Is it a vocational option? Are they going to go to work? Is there a transition program or a day program? And we really encourage families to start touring some of these programs and looking at them. Some of these programs have very long waiting lists. And so you want to get your name on the waiting list. And a lot of them are going to require a tour first before you get yourself on that list. And then the other thing that we would like to share, and I'm sure Randy that you would like to chime in on this, we suggest making careful considerations before naming siblings as a future caregiver. And I'm not stepping on anybody's toes here. Again, I have multiple kids with disabilities. And what I would say is, just like you did, or like I did, when you're 18, 19, 20, 25, you have hopes and dreams. Maybe you're going to get married. Maybe you're going to go to school. Maybe you're going to have a substantial career. Maybe you want to have a family of your own. And our other kids have those hopes and dreams too. And sometimes if they're saddled up with a caregiving responsibility, they may not be able to do some of the things that they had hoped for. So we like to see siblings maybe as a future trustee of a special needs trust that is properly funded to be able to provide care for said person with an individual, but not necessarily their caregiver. So having said that, Randy, we are so glad that you are here with us today. Tell us about Legacy Solutions Law Firm and a little bit about yourself, and then we'll dive right into the content.
Thanks, Allison. I will try to speak about myself as little as possible. The real purpose of the presentation today is to provide you as much information as possible, right? There's only two promises I want to make today. The first promise is to provide you as much content as I have. We're here till 1 o'clock. I know everybody is busy. We all have lives that require a lot of attention, and you took some time out of your day for today. So my job, along with Allison, is to provide you as much good information as I can to help you have some clarity when you leave this webinar today. The second one is, and I'm sure Allison, not sure, but Allison could give you the opportunity to discuss what she said further, right? Um, you know, uh, Allison alluded to a little bit that, we create structures like a special needs trust, and there's a lot of details in that that's really important. And it's kind of like building a car or deciding what kind of transportation you need. But working with somebody like Allison helps you figure out what that type of transportation is. All right, so a little bit about myself. I have been practicing for about 11 years now. And since I started practicing, my practice has focused on estate planning and special needs estate planning. And it's something I'm really passionate about. The main reason that I'm passionate about it is just because that is what my mentor did. That's what he trained me in, and that's what I really like to help clients with. And it's very simple. Our firm wants to protect your family, preserve your assets, especially this is especially true when you have a special needs child. You can never overfund the special needs trust, and to make sure you leave a legacy of positivity and not a legacy of blame. Allison, if you can go to the next slide, that'd be great.
It's freezing, so bear with me. Oh, wow. Okay.
Sure. Yeah. All right. Perfect. Well, you jumped forward just a little bit. Um, all right. So just a quick disclaimer. We are a law firm located in Broward County, Florida, and we help clients around the state. And the information I'm going to give you today is applicable only within the state of Florida. And if you are coming here from outside of Florida, you're welcome to stay. About 90% of what I go over is going to be applicable to you, but there's obviously really important nuances. And if wherever you are in Florida, if you have a child or a grandchild or a relative or someone you care about with special needs, this will be applicable to you. Also, second quick disclaimer. I say your child all the time. I realize that everybody here might not necessarily be a parent of a special needs child, but just to keep it simple, that's what I do. We're going to cover 5 topics, and I'm going to try to give you as much information as I can. Like I said, I promise you to provide really good value. And the first is, what are trusts and what are special needs trusts? Next are the benefits of special needs trusts. After that, we'll talk about the different types of special needs trusts, other important estate planning considerations, and trying to balance and understand the differences, the pros and cons between special needs trusts and ABLE accounts. All right, so a lot of you are here, and God willing, you're very healthy and you're not really thinking of a time when you're going to be incapacitated or die, but you know that that is a reality of life. And there's a question of why would you engage in planning now? And the truth is that you have the most leverage. You have the most opportunity to plan. You have the most opportunity to put a plan into your place, create a life care plan with somebody like Allison, coordinate everything properly, find the right trustee to manage things, find the right person to take care of your child, find the right person or program for them to be a part of to create some continuity or living arrangements or whatever that might be. And when you're alive and well, you have the time to put everything into the place the way you would want to do it. If you wait too long and you become ill, you rush through it, the plan won't necessarily be as good. You put the people around you in a very uncomfortable situation. And, like you could see on this chart, the fees get higher, right? You're paying more because you're rushing and you're trying to figure out and put things together. And then unfortunately, if you wait too long, you're going to put a tremendous amount of pressure on those people around you, and you're not going to necessarily have a well thought out plan to take care of your child. So, is the webinar relevant to you? Well, number one, you want to ensure your child is protected no matter what the future holds, right? So, that is what planning is about. It is about coordinating with experts like Allison and I and other professionals to make sure that your child has a plan into place that takes into account all of the things that we've seen in our professional world. And you can have a plan into place that life is very unpredictable. And that is what planning does. You're concerned about how your estate will provide for your child, right? You hear all kinds of stories about the government coming in and taking money, uh, or taxes, or making sure that your child receives the right benefits. You want to make sure that your child has a plan that's going to provide for them and in increments for the rest of their life. You've also heard about special needs trusts and you're really not sure what they are. You're just here for curiosity, just to learn a little bit. And you want to make sure your child's financial future will be managed responsibly without access to benefits. Allison mentioned that before. Do you want a sibling or, one of your other children managing things? Sometimes, maybe not. But you want to make sure that your child's access to benefits and all of the resources that they need to provide for themselves are available to them. So, without jumping right into special needs trust, I find a lot of people don't even know what a trust is. And the best thing I could do is compare it to a business because people are relatively familiar with businesses, right? Um, so let's say you have a business and there's some paperwork that you create to start that business. And in that paperwork, there's a bunch of rules about how that business works. Then there is the manager of the business, right? That person is deciding how to use those rules on a day-to-day basis. And who are they doing it for? Well, the shareholders, right? The people that own the business. And that's kind of like a trust. A trust is just a set of paperwork and it creates a legal entity. It's not registered with the state like a business is. And the person who manages that um, trust, like a business, is called a trustee, and they manage it for a beneficiary. So, for example, if a trust owns a bank account, the trust itself can say, what can that person do with that bank account? And what can the trustee do with the bank account? And who can they use it for? And the who can they use it for part is the beneficiary. So you can create a trust that you can be the trustee, the person who creates it, the beneficiary, or you can name other people in those roles. Now, transitioning that into a little bit of a special needs trust, I'll also just say one other thing. If you have any questions during the presentation, feel free to throw them in the chat and we will answer them to make sure that you walk away here with the information that you really are interested in. So a special needs trust is a form of a trust, and it works like this in a very simple way. You would create this trust. There's different ways to create it, but you create a trust for the benefit of your special needs child. So they're the beneficiary, and you name somebody else to manage that trust for your child. An example could be that you name a bank or a trust company to manage the trust for the benefit of your child. And when you pass away, everything that you owned is now in that trust. Let's forget about the details of how that happens. And that's the very basic structure of how a special needs trust works. There are some nuanced rules of how that trust works. One of them, for example, is that the trust needs to be managed for the sole benefit of the special needs beneficiary and not multiple beneficiaries together.
You just said something that is key, and a question that we get on a pretty regular basis is, if I have more than one special need child, can I have just one trust? And that answer, based on what you just said, is no. You really need separate trusts for the various children if you have more than one. Is that correct?
Yes, that is correct. And technically, you can create multiple trusts under one document, or sometimes you have two documents. I'm going to talk a little bit about that later on. But yes, each child would need to have their own special needs trust, and the funds would need to be, the assets, the things you own would need to be completely separate from each other.
And one other thing I wanted to mention, Randy, is that that said child could have multiple special needs trusts. There could be a divorce situation and dad has a special needs trust for said child and mom has a special needs trust. Sometimes grandparents may have a special needs trust for the said child, and that is all okay. Because we've seen both scenarios where it's a good, divorce and they're okay with having one trust, and then we've seen not so good where everybody wants their own, and that's okay too. I'm sure you've seen that on a regular basis as well.
I have, and ideally, it's nice if everybody can get along and have one special needs trust together. That works out really well, just because the simplicity of it. But it's not always the case. Uh, you, the question made me think of a major problem we see when people hire attorneys who do not do a lot of this work, is you would ideally like to have language in a trust that potentially allows different trusts to be merged together, so that you can not have to file necessarily two or three different tax returns and can only file one. That doesn't always work, but ideally you want to have that flexibility and ability to do that in the trust.
Randy, before you go further, I want you to touch on the testamentary special needs trust, because although that is one way, to go about it, and that's basically when there's language in your will that says the special needs trust will be established upon your death. Some of the problems that we have seen with that, and I'm not for or against it, but if you have any family members, aging parents, grandparents, or other people that would likely leave money to your loved one with a disability, then that lends itself to that you would need a standalone special needs trust, because you didn't die, so your special needs trust doesn't create when mom or dad dies. So
Yeah, and
sometimes people lose that little piece when they're thinking about their options.
again, and this isn't a commercial, but that's why it makes sense to work with somebody who does a lot of special needs planning, because that exact issue, and people don't really necessarily know the nuances. Yes, sometimes it makes sense to have a standalone trust. Sometimes it could make sense to have a testamentary trust. And actually, in a few slides, I'll go through some of the pros and cons. But the one you said, when other people want to leave money to the trust, is in my opinion, the number one reason to have a standalone special needs trust. Um, the main purpose is, and I'll go into these in more detail in the following few slides, is this is what we find people are most concerned about and the value that a special needs trust provides. Number one is protecting the benefits of a beneficiary. Number two is to provide for supplemental care that those benefits themselves will not provide for. Three is to provide long-term security, meaning sometimes beneficiaries need protections from themselves and others. And then last is flexibility and control. And I'll go into more of those as we go through this. So protecting benefits. Medicaid waiver is one of the most important programs that a lot of our clients' children are on. And then also obviously SSI and Medicaid and other benefits. A lot of these benefits are means tested, meaning that if you have too many resources in your name. By resources, money. That's a good way of thinking about it. Money or things that have value in your name, then you may not be eligible, or too much income, you might not be eligible for these benefits. And a special needs trust, if done correctly, the primary function of it is so that the money in the trust can be used for the benefit of the beneficiary without losing those benefits. And there's a lot of rules how that money needs to be used in the special needs trust. But if the person managing the trust, the trustee, does that correctly, then the benefits should be preserved. The next is examples of supplemental care. These are, as any of you know who have children who are receiving public benefits, it is far cry from what they actually need to provide for their care and support. And there are regular care and support items that come up, for example, therapies or caregiving services. And then there's other large one-time expenditures, things like home modifications or vehicles or assistive devices or specialized services or whatever throws things in your life. These big expenses need to be paid for. And the trust allows money to be reserved for these unexpected expenses through life. I mean, somebody like Allison puts together a plan that explains what those unexpected expenses are, but the trust allows that those things to be paid for. The next, one of the major concerns we often hear from clients is that they are worried about somebody taking advantage of their child. This is especially true if the child is very high functioning. We get reports that they have children who people try to take advantage of, or will trust people instantly. And having the trust is a safeguard to protect the assets in the trust for the benefit of the child, because one of the other features of a special needs trust is that the beneficiary themselves cannot directly access the assets in the trust. So it provides protection. The other thing that it does is protect the beneficiary from themselves, so they don't necessarily take out money and squander it on things that are not necessary for them. But the balance of using this money for them is not a problem. That could be done within the trust. But again, this way, nobody is taking everything that you left for them.
So one point, and I think it's important to make, because if we have people that are here that their kids are not getting public benefits such as Medicaid or SSI, there's basically two places that you can have money above and beyond that means test that Randy was talking about. And for most cases, not in every state, but the Medicaid limits are $2,000. You can have one house, you can have one car, but the special needs trust and an ABLE account, which we'll get to later, is a place, and you can have an unlimited amount of money for said individual in the special needs trust, and it definitely will not count against them for their public benefits. So that's why it's so important. And a lot of times, we haven't thought about this. If we have minor children, they didn't have any money in their names, we made too much money, the kids didn't qualify for SSI or Medicaid or weren't getting a Medicaid waiver. So it may have not been important up until this point, but there is this point in time where it's critically important. So I just wanted to mention that for people that may not be getting public benefits yet.
Thanks, Allison. That's right. Again, the trust can also be set up in a way, and I'll go through this slide very quickly, but just life changes. I mentioned it before. There's different things that happen in life, and the trust can function in a way to be flexible with those changes in life. That could be potentially changing residences of an individual. So let's say, your child moves from one state to another, or the person who is managing the trustee can't do it anymore. Those types of occurrences can be designed through the planning session to ensure that the trust works in a way that can fluctuate again with your child's fluctuations, or the life's fluctuations that affect your child. So just most people are likely thinking about third-party special needs trust, and I'm going to explain the difference of them as opposed to a first-party trust. But it works like this: a first-party trust is a special needs trust that is funded with an individual's own money. So if you have a special needs child who does not earn money, because they can't work. For example, money can come into their name either through an inheritance where there wasn't proper planning done. So let's say a grandparent leaves money to the child, but they didn't have a special needs trust, or a personal injury action. An individual's injured, let's say, for example, in a car accident. And as a result of the lawsuit, they settle money. So that would go into a first party trust. It's that individual's own money. A third party trust is when the money comes from anywhere else: parents, siblings, grandparents, friends, aunts, uncles, cousins, whoever it is that's not the individual themselves that's receiving the means tested benefits. The major difference, although there are some other differences between these trusts, between a first party trust and a third party trust, is that the money in a first party trust needs to be used to pay back the government for benefits that they paid on the individual's behalf. So if you do not do a third party trust planning in advance, then it is possible that whatever your child would inherit would need to go into a first party trust. And instead of that going to other family members or causes you believe in or friends or whoever you wanted to after your child will pass one day, then that money would potentially go back to the government. And that's something that a lot of people want to avoid.
Randy, I just wanted to mention that there has been, we get this a lot. People say, well, I heard that they got rid of the Medicaid payback. And it is true that there has been some proposed legislation to get rid of the Medicaid payback, but it has not passed yet. So if you have heard that, I just like people to know that it just hasn't passed yet. We hope one day it will. It's probably no time soon, but they have talked about that.
Yeah, it's possible, but as of right now, it has not. And we actually deal with letters from the state agency regularly about payback for any money that's paid to somebody for Medicaid. So a third party trust, again, they could be funded by anybody. There's a lot of flexible management in that to provide for the individual and to tailor it to your specific circumstances. And it provides long-term security. And now I'm going to talk about a little bit what Allison was talking about before, the difference between a testamentary and a standalone special needs trust. So a testamentary trust is just a way of saying that the trust comes into existence after you passed away. And it can either come into existence under a will, although we don't really do that, or a living trust. So the money goes into this trust after you pass away. It's usually nestled in there right under your estate planning documents, and it comes into existence when you pass away. And if you have, for example, two children, one with special needs and one that does not, that trust will usually half, or let's say you're leaving it 50-50, which is not always the case, but half could go to one child and then half could go to the special needs trust for the other child. The other type of trust is a standalone trust, and it could be funded now. You could start putting money in there now, or at any time that could be coordinated with anybody's estate planning, like a grandparent or a different parent. We get divorced couples who want to do this type of trust together all of the time, or other relatives. So the benefits of a testamentary trust is it's cost effective. Whether cost is your primary concern or not, it is for some people. And the ability to have a third party trust that protects the assets along with an estate plan that's appropriate for you, combining them together in a testamentary trust overall costs less money for an attorney to prepare. Another benefit of a testamentary trust is a predictable allocation. If you're not using the trust for inheritance from somebody else, but just for you, and you start putting your own money in there now and you have multiple children, it's possible that because of changes in your circumstances, or your assets get reduced for whatever reason, or you need to spend money on your long-term care costs, it's possible that there's an unequal allocation between the two trusts. And then the other benefit is that there's a delayed funding, which is could also be a downside, but it's only funded on your passing, which preserves the money for you. So some people want to make sure that they can stay in their house with their child as long as possible. Sometimes it's not with your child, but you want as much care and support for yourself. I know as parents, we love to put our children first, but sometimes we need that money to take care of ourselves. And if you put that money into a third party special needs trust, a standalone trust, that money would not be available to take care of you during your lifetime. The advantages of a standalone trust are you can make immediate contributions. So it allows other people to make contributions for your child. That money could start being used for your child if they're getting public benefits, or if they're not, it could still be used for them. And if they're getting those benefits in the future, those will be preserved. And it allows people to make gifts, either lifetime gifts or in their estate plan. These types of trusts, we send them to Social Security for approval. If it is a standalone trust, we could send it to for approval now. It gets faster approval and gives you more confidence. Number three is if you're not the trustee of the trust and you want to just name somebody else to manage it now, you can have an opportunity to develop a relationship with a corporate trustee or a third party trustee of some sort to make sure they're the right person, and you could potentially change that during your lifetime. And then also there's instant funding when you pass. Even though money in a testamentary trust can be put into the special needs trust relatively quickly, between the time of getting death certificates and filling out forms and doing all of the administration that needs to be done, it would take longer than with a standalone trust, and having that money available right away to continue to provide a continuity of care for your child. Um, this is just to help you wrap your head around an idea, which is funding the special needs trust. People don't really understand, how does my stuff get into a trust or a special needs trust? It's not that complicated. Once you do it, it's easy to see, but it's just a matter of titling. So for example, if you had a standalone special needs trust, you can go to the bank with a copy of that trust, just to keep it simple, and you could say, I'd like to open up a trust account, and let's assume your name is Jane Smith. Instead of the account being in the name of Jane Smith, it could be Jane Smith, trustee of John Smith's special needs trust. It's just a matter of titling. So things like cash, securities, real estate, business, even businesses, those can all, life insurance policies, they could all be owned within a trust. And retirement accounts, even if they're not in the trust can be the beneficiary of retirement accounts, which I'll talk about a little more in a second. So with retirement accounts, the trust, there are some benefits under the tax law to being an individual who inherits a retirement account. An individual who has special needs who inherits a retirement account. There's some benefits for different classes of people, but there needs to be very specific language in the trust that makes it so that the IRS looks at it as if your child with special needs is the one inheriting the retirement account. The technical details are, conduit trust versus accumulation trust. But what I'll say is this. If you are speaking with attorneys about special needs trust and you have money in a retirement account, or if you're working with somebody like Allison who can have this conversation for you, just make sure that the attorney understands the implications of this, because the downside to not having the right language in there is extremely significant and can cost thousands, if not tens of thousands, if not hundreds of thousands of dollars, depending on the size of your retirement accounts. Just to keep it very simple, it's a matter of your child potentially having to use that money within 5 to 10 years, or being able to have that money grow tax deferred for the remainder of their life. And those numbers can be extremely significant with compound interest.
So, Randy is talking about required minimum distributions from IRAs, and if you haven't got to that age, you might not know about that. But when we have qualified money in IRAs, we are required to take money out of that at a certain age. And when you inherit an IRA, you're required to take that out over a 10-year period, unless you are an individual with a disability. And then they have that, what he was mentioning is the lifetime stretch rule. But the only thing I wanted to comment here is that there are very specific rules. So not only do the documents need to be right, the company has to be notified by October of the following year of death, and you have to have all your ducks in a row, or you're not going to get that lifetime stretch. And the lifetime stretch is great because you can, extrapolate that out over the lifetime and reduce the taxes annually that is going to have to be paid. So it is an important consideration. And then the other thing on your previous slide, Randy, I wanted to mention, we often see people using life insurance to fund a special needs trust. And the reason why is because that keeps their assets nimble for the 25 to 35 years that they may be spending in retirement, like you were talking about earlier, the access to the money while they're alive. So clearly there are people that have millions of dollars and they fund the trust with their millions of dollars, and there's other people that have saved up over their careers and their lifetime, 30 or 40 years, and they have this nest egg. But a lot of that nest egg is going to be needed to be used during retirement. And that's where that life insurance comes into play. And the only thing that I wanted to mention here, because I'm not sure if you have this in the slide, but one of the things that we frequently talk about, because we see common mistakes, and if you've made this mistake, it's no big deal, it's easily fixed. But it is critically important not to name your loved one with a disability directly as a beneficiary on anything you have. Commonly, what we see is if you're married, your spouse is your beneficiary, and if you die and the spouse is dead and gone, then that's easy. We divide the money between the kids. We see that very often. And but when it comes to a person with a disability, the right way is to name the special needs trust for the benefit of said child, to avoid sometimes, Randy, we call it an oops trust. Oops, somebody left my kid money directly instead of to a special needs trust, and now I need a first party special needs trust. So I just wanted to mention that. So if you're taking notes today, by the way, everybody's going to get a copy of today's slides and a link to the recording following this presentation. But if you're taking notes today, do check your beneficiaries. Check your life insurance with employers, outside of employers. Check those pension plans, 401ks, 403bs, old pension plans or retirement accounts that you may have had from previous employers, because those are things where we see accidentally this mistake on the beneficiaries. So if you've made this mistake, it's not a big deal. Don't beat yourself up. All you have to do is call the company or the carrier and request a change of beneficiary form. Once you have your special needs trust set up, then you can change those contingent beneficiaries or beneficiaries to the special needs trust for the benefit of said child. It will cost you nothing. You don't even have to hire anybody to do that. So I just wanted to mention that.
Great, thanks, Allison. Great points. This is the next few slides are just common issues that clients ask about. And this is balancing the needs of multiple beneficiaries is the first. Our clients sometimes struggle with how to leave their assets to their children when they have multiple children or multiple beneficiaries they want to leave everything to. And these are very small snippets of conversations that I have with clients all the time. We discuss the concept that fair doesn't necessarily mean equal. Sometimes a child's earning capacity is much lower than another child, and the needs of one child are much higher than another child. And that should be taken into account when trying to make these types of decisions. This is where somebody like Allison can really come in handy when trying to make these types of decisions, because a lot of this can be just guesswork, right? Like, how much does my child need? How much do we think, right? I ideally like to leave 50-50, but I don't know if 50-50 is enough. So getting professional advice on what fair is, uh, doesn't necessarily always mean it's equal. Sometimes it is, sometimes it isn't. I also am a huge fan, unless you don't want to, of communicating with family members who do not necessarily have special needs, or sometimes do, to be part of this discussion and meet with the family and have a discussion all together, not necessarily in making this decision, but in explaining the decision. Because we find that the biggest problems that happen after somebody pass away, after even if they have estate planning, is a lack of clarity from the children or a lack of understanding of why decisions were made. So getting everybody involved and having that communication is really valuable. And then also the third is consider lifetime giving, which is, you know what, maybe you need to leave more money to your child with special needs, but maybe you can, in exchange, give money to your children who need it more now, right? To maybe buy a house or start a business or just renovate their house or buy a car. I mean, all different budgets for all different things. And that can really make a huge difference in trying to balance out how much you're leaving to a child.
Randy, I just wanted to mention a couple of things. First, doing those lifetime care plans, the future care cost considerations, that's something that we do. We do a complete analysis specifically tailored to the said individual, and we do a future care cost estimate. And this answers that question of how much money do I need to fund the special needs trust. And we do it what I call small, medium, and large. We have some families that they know beyond a shadow of a doubt that the person is going to need full care for the rest of their life. We have some families that may have a kid that's on the spectrum and they're hopeful and optimistic, but they haven't arrived yet. So they want to plan for the worst and hope for the best. So we help get those numbers in place of what are we looking at. And we can take into consideration any residential living facility that you're looking at or thinking about. And then the other thing about your communication piece, Randy, we were talking about beneficiaries a moment ago, and one thing that we have found, it is critically important to have intentional conversations with your aging family members, parents, grandparents, people that have affluence that might want to leave money to your child. And what we know is that people in that generation, oftentimes they keep their cards close to their chest. They don't like to talk about dying, they don't like to talk about who's getting what. But what we encourage families to do is say, we've started planning for special needs for little Johnny, and we've learned that there's a right way and a wrong money to leave money, to Johnny for Johnny's benefit. And we wanted to share that with you. For this reason, we've set up a special needs trust, and we wanted to let you know the right way and the wrong way. We're not assuming anything, because your parents and grandparents, they want to do it the right way. But when I said earlier that fewer than 150 financial advisors in the US have any background in special needs, what happens very quickly? Grandma and grandpa go to their financial advisor and they say, we have this grandson and he has special needs and we want to help him. And the advisor says, great, what's his name? And the beneficiary gets changed to your child's name. And you may not even know, if you don't have these intentional conversations, until the person passes away, and then you need the first party special needs trust. So I think it's really important to have those conversations. You don't have to get in their business. They don't have to tell you how much money they have or anything like that, or even what their intentions are of who they plan to leave money to. But at least they know they have the name of the special needs trust, the tax ID for the special needs trust, and then they have some guidance. And a lot of attorneys will give you a paper of how to set up those beneficiaries. Some attorneys will help you with that as well. So I just wanted to mention it because it's so important.
Yeah, and Allison also alluded to the next slide earlier, is who do you pick as a trustee? Let me start with this. You don't have to name one trustee. You can sometimes name co-trustees. But I'm going to tell you, people often consider family. I see a lot of downsides with it, but I also see a lot of upsides for the right person. Um, what people love about the fact of individual trustees is usually a family member, someone they have a personal relationship with, someone they trust. Um, but and then also that they're taking into account, wow, banks are going to cost, or corporate trustees or professional trustees are going to cost a lot of money. so that there's lower costs involved, or seemingly so. And but the downsides are is, number one, if you're picking another child of yours, there's potential conflicts involved. So, for example, if you have two kids, John and Jane, and John has special needs, and after John passes away, Jane's going to inherit, there's a potential conflict that Jane wants to spend less money on John. There's also limited expertise. Most attorneys, even that do estate planning, very, very few of them do a lot of special needs estate planning. And those are attorneys, and those are estate planning attorneys. Um, but the regular world, people not in this world, have no experience with special needs trusts, and there are nuanced rules. And this is a little bit of a conflict with the lower cost. But if you mess things up, it could be very expensive to fix. So there's a limited expertise. There's also a lack of continuity. People get sick, people's life circumstances change, people die. And if you had your one person, your one go-to person, and they're not there anymore, that could be a problem. In terms of corporate trustees, the main benefit is that there's professional management, right? There is a team set up to be able to manage this in the proper way according to the law. There's also continuity. Companies don't die. They could get bought, they could transfer, those things do happen, but there's going to always be a continuity there of the trustee. There's also objectivity. There's no conflict. They're not inheriting anything if the individual passes away. And then also expertise, right? There are some companies that do this day in and day out, and they know special needs trusts like the back of their hand. They are true experts. One of the two downsides are to people that they cost more. They cost more money upfront than an individual who's not charging anything. And in some situations, there's less personal connection, right? Even if you like the person when you decide to hire somebody, they are not necessarily going to be the person who is doing it 20 years from now, 15 years from now, 10 years from now, even 5 years from now or less, when the corporation or the professional trustee takes over. So those are some things to think about and what's important to you in making that decision. Allison, you wanted to add something?
Well, we've heard of people saying, I didn't get a special needs trust because I just basically disinherited my special needs child. And I gave everything to his sister and she's going to take care of him. And to your point, people die, people get divorced. And when we do that, so can you do it? The answer is yes. Is it the right way to do it? The answer is no, because it could get tied up in probate or other things where even though the sibling had great intentions and planned to take care of said sibling, but when life happened to the other sibling, it could kind of derail that plan. And so that's why we advise against disinheriting your special needs child, even though you have somebody, a person of trust, because anything can happen in that person's life.
Yeah, that's such a good point. That should have been a slide I discussed. It's such a common idea that people have. That's honestly, it's just not a good idea. So I really agree with that. A trust protector. This is here just to let you know, if you're not sure who to pick as trustee, or you like them but you want another layer of protection, you can set up a trust in a way to have somebody oversee the trustee and make changes if they're not really managing it the way that you intended the trust to be managed. And it's something you can do. The trust protector could also do a lot of other things, like change the trust based on changes in law or taxes or things like that. But in terms of the trustee, the trust protector can be an overseer and just making sure that the trust is managing the trustee is doing their job and managing it right and taking care of the beneficiary in a compassionate, loving way, the same way you would want them to be taken care of. Able accounts for special needs trusts. I'm There are pros and cons, and I'm going to simplify it like this. If there's a small amount of money that you want to leave to a special needs beneficiary, an able account is a great tool. And when I say a small amount of money, anything under $20,000. And if there is a larger amount of money, like your inheritance, part of your home, your retirement accounts, your savings, life insurance, then a special needs trust is a better vehicle. I will say, though, that in our special needs trust, we include language that allows the trustee to establish an ABLE account, because ABLE accounts can be used strategically to potentially provide more residential services to a special needs beneficiary without impacting SSI that they're receiving. And you never know when it might be a good option to use an ABLE account as opposed to a special needs trust. It depends on the able company, but the federal rules state that there's a Medicaid payback provision for able accounts. So it operates somewhat like a mini first party special needs trust. There are some distinctions, but understand that the money in an able account could go to pay back the government, where that is not going to happen with a third party trust. And then there's definitely more flexibility within a third party special needs trust than an ABLE account. Um, but like I said, the ABLE account is a great tool. It's just not necessarily the best way to plan around inheritance. But there are other reasons that it can be used. Allison, you probably talk about this a lot.
Yeah, I like to see ABLE accounts used in conjunction with the special needs trust. Most of the families that we serve have both an ABLE account and a special needs trust. And to your point, there's an unlimited amount of money that can be in a special needs trust and a limited amount of money that can be in an ABLE account. If you have more than $100,000 in an ABLE account, you're going to disqualify for SSI. You can still keep Medicaid. But to your point, Randy, you can pay for shelter out of an ABLE account without a 1/3 reduction to SSI, and that's supplemental security only that I'm speaking of. And one other component, so, when you were talking about the lower amounts of money, the contribution limits for 2025 is 19,000, and it's subject to the gift tax exclusion, whatever it is for the year. So it changes every year. And if the individual is working, they can put an additional 15,560 for 2025 up to their earnings amount. But one component that you can't do is make an ABLE account a beneficiary. So if I have $15,000 that I want to leave and I want to make the ABLE account a beneficiary, you can't do that. It would go directly to the said individual, and then the individual would have that put into an ABLE account. There is no such thing as of having that as a beneficiary. Whereas you can definitely make a beneficiary the special needs trust for the said beneficiary. So I just want to make sure that the distinctions are there. And if you're hearing this for the first time, I just want to invite you to the Consolidated Planning Group YouTube channel. We have entire webinars on ABLE accounts and how they work. We don't have enough time to go into all those details today, but we definitely have more information out there for you on that.
Usually when we're doing special needs trust for individuals, we're doing it in coordination with their estate plan. And a lot of times sometimes people did their estate plan and they didn't do a special needs trust. So we're redoing their estate plan or coordinating it all together. But if you haven't done your estate planning, and if you have, great, you can sleep well at night. But if you haven't, the main benefits are, number one, reducing family conflict. Estate planning creates clarity, and nobody wants to leave family fighting. Number two, avoiding probate. And probate in Florida could be quite expensive. The attorney's fees by statute are 3% of the value of your estate. So $1 million is $30,000. And it also can take 9 to 15 months or longer in Florida. Also avoiding a legacy of blame. We have clients that come in here all the time doing their estate planning because their parents did not do it, and they're remembering their parents for being disorganized and not putting things together properly. Also, the wrong beneficiaries. If you don't do planning, the state is going to decide how your family inherits. It's particularly problematic when you have a child with special needs. But even if not, just the state saying who gets what. This is also particularly complicated in blended families with second or third marriages. And then also, life happens, right? People become incapacitated. People can't make decisions for themselves, and you want to make sure you have decisions and documents in place to make sure that you're taken care of. It's kind of like putting the oxygen mask on first, and then making sure that you're stable so that your family can be taken care of also. Just and this goes for any professional advisor, but if you're going to choose an attorney and you have a special needs child, make sure that their focus practices on special needs estate planning. Also, make sure they practice collaborative based planning. You know, all the work we do as a law firm is very, very important. It's necessary, but if it's not done in consultation with people like Allison or CPAs or the right professionals, the plan can fall flat. These professionals bring life to it, and we work with them to make their plans come to life. So make sure that they actually work with other professionals, and it's not just they you hire them, they print you documents and they send you on your way. Make sure they're willing to talk with your professionals. Also, make sure they charge a flat fee. Estate planning is relatively predictable, and a professional should know what it should cost to be able to provide you the services. And you don't want to be afraid to call your attorney and ask questions because you're going to get bills. You want someone who is a professional who's going to charge you a fair fee and you not have to worry about unexpected bills. Also, make sure they're going to put a process into place to keep your estate plan up to date. Life changes, and so do you. And there's divorce and death and sickness and people falling out, having fallouts, or whatever the case may be, or moving. And so make sure that there's a plan to keep it up to date, and also make sure you like the person. This is a really, really personal process, and you have to have very personal conversations. So make sure you can connect with the person so that you feel comfortable having those conversations with them.
Randy, we work with a lot of families. All the families have kids with disabilities, and we see a lot of things. We see people that don't have any legal documents in place, no will, no trust, nothing. We see people that have documents in place that maybe they did 15 years ago. Maybe their most recent child isn't even listed. We really encourage people to have their legal documents evaluated, every 3 to 5 years. Things change, laws change, they get updated and things like that. And it doesn't mean that you have to redo everything, but to your point of that process in place to keep it up to date, I think it's really, really important because of those changes that happen. And so I always tell people this isn't a let's beat ourselves up about what we haven't done. You're here today, and we're glad that you're here. It's about looking forward. What have you already put in place? What have you already done? Did you have your documents created by an attorney that basically doesn't have any background in special needs? Is it time to have it reviewed? And so thinking about those things and just picking up where you left off, never beat yourself up about what you haven't done. Our job as parents with loved ones with disabilities, whether it's a child or another, family member, it's a lot. It's a full-time job on top of all of the other full-time hats that we wear. So don't ever beat yourself up about where you are in the planning process. Some people have done a lot of planning and they want a second opinion with professionals that are nuanced and special needs. Some people need to get started and some people need to pick up where they left off. And all of those things are definitely okay. So
Um,
this
yeah, oh, sorry, go ahead.
this is your contact information or a little bit more about Legacy Solutions.
Yes.
And what were you going to say?
No, just nothing really. People are here for an hour. We want to make sure we finish on time so people can get back to their busy day. Um, just if anybody is interested in doing their estate planning or they just want to have a conversation to see if it's right for them, feel free to book a discovery call. If you end up deciding that you do want to do your planning, we will give a discount to anybody who attended this webinar today. So just make sure you let Ivan know who you would speak to. And if you want to I'll put the link in the chat also. It's a 10-minute phone call, doesn't cost anything. If you want to just figure out if planning is right for you, feel free to give us a call, no pressure. And otherwise, it was just awesome, to be able to provide some education to you, to provide you some value today.
Well, we talked about a lot of great things, and Randy, we're going to have you back, and we're going to take a deep dive into guardianship and alternatives to guardianship. So we want to talk about that for Florida residents. Again, everybody's going to get a copy of today's slides. This is just some things to keep on your special needs planning radar. We talked about special needs trust and kind of dabbled on ABLE accounts and beneficiary designation. There are waivers, Medicaid waivers in every state. We serve all across the United States. All states have Medicaid waivers, which are designed to waive off some of the cost of care for caring for an individual with a disability to keep them in home and community-based services. And unfortunately, Texas and Florida jockey for the two longest waiting lists in the United States for waivers. So it's very long, 17 to 20 years to get a waiver. But you do want to get on those lists. Learning a little bit more, those future care cost estimates, how and when to apply for SSI, SSDI, other benefits like childhood disability benefits. We have webinars on all of these topics, so you'll want to check that out on the YouTube channel. Today, when you get a copy of the slides, you're going to have a link to our upcoming webinars. So you can register for those on any of the topics that might be of interest to you. We work on a collaborative team here at CPG, and we always offer free personalized consultations. So if you've heard some stuff, you have some more questions, maybe you didn't ask today in the chat box, this QR code, you can hover your camera over that and take you to our calendar where you can schedule your free personalized consultation. Well, Randy, it was certainly a pleasure being here with you today. Lots of great information. It was awesome. And we look forward to partnering with you again on a guardianship webinar. Thanks, everybody, for being here. And I should have said in the beginning, this is our inaugural first Florida webinar that we've done. Again, we work all across the United States, and we wanted to get this started in our webinar series in Florida. So for our participants today, you are our first Florida webinar. So thanks for being here. Thanks, everyone, and I hope you have a great afternoon. Take care.
Thank you, everyone.
Bye now.